Have you recently reviewed your product labels? If not, now is the right time. A small compliance error on a product package may seem insignificant, but it can lead to regulatory inspections, financial penalties, disruption in product sales, and even affect your business reputation. The legal metrology framework in India has undergone several important changes in 2026. These amendments affect manufacturers, importers, packers, distributors, brand owners, and e-commerce sellers dealing with pre-packaged commodities. From the Jan Vishwas Amendment Act and revised penalty provisions to changes in LMPC rules, e-commerce obligations, and the latest advisory for edible oils and fats, businesses are expected to strengthen their compliance systems. In this video, we'll explain these changes in simple terms, highlight their practical impact, and discuss the steps businesses should take to remain compliant. Welcome to mindsync. We are a regulatory consulting firm dedicated to helping businesses navigate India's evolving compliance landscape. Our expertise covers legal metrology, BIS certification, quality control orders, environmental compliance, import regulations, and various business approvals. At mindsync, we believe compliance should never become a hurdle to business growth. Instead, it should become a competitive advantage. Through this video, our objective is to simplify the latest legal metrology developments and explain how these changes may impact your day-to-day business operations. Whether you manufacture products in India, import packaged goods, operate an online marketplace, or manage compliance for your organization, this update is designed to help you understand the latest regulatory expectations. Why these changes? Before discussing individual amendments, let's understand why these changes were introduced. Over the years, the government has been working towards creating a compliance framework that protects consumers while making it easier for businesses to comply with regulations. The emphasis is gradually shifting from excessive penal action to encouraging voluntary compliance. Digital commerce is expanding rapidly. Consumers expect greater transparency. Businesses require simpler compliance procedures. Keeping these objectives in mind, several amendments have been introduced under the legal metrology framework during 2026. These reforms are intended to improve transparency, strengthen accountability, reduce unnecessary litigation, and encourage businesses to proactively comply with regulatory requirements. Jan Vishwas Amendment Act. One of the most significant developments this year is the implementation of the Jan Vishwas Amendment of Provisions Act 2026, effective from the 1st of May 2026. This amendment brings important changes to the Legal Metrology Act 2009. The objective is not to weaken compliance but to create a more balanced regulatory framework. Instead of immediately resorting to punitive action, the law now places greater emphasis on giving businesses an opportunity to correct non-compliances. The amendment also revises inspection powers, modifies provisions relating to offences and penalties, introduces an improvement notice mechanism, revises compounding provisions, and provides for periodic revision of penalties. Overall, the government aims to promote ease of doing business while continuing to safeguard consumer interests. Improvement notice. One of the most practical changes introduced under the Jan Vishwas Amendment is the concept of the improvement notice. If a legal metrology officer identifies any instance of non-compliance, the officer may issue an improvement notice before initiating enforcement proceedings. The notice clearly specifies the grounds on which the officer believes there has been a violation. It also identifies the exact nature of the non-compliance, the corrective measures required, and the time within which those corrective actions should be completed. This gives businesses an opportunity to voluntarily rectify deficiencies and strengthen their compliance systems. However, businesses should remember that an improvement notice should not be ignored. Failure to implement the required corrective actions within the specified timeline may result in further enforcement action under the Legal Metrology Act. Therefore, organizations should establish effective compliance monitoring systems and respond promptly whenever such notices are received. Revised penalty framework. The Jan Vishwas amendment has also brought substantial changes to the penalty provisions under the Legal Metrology Act. For certain offences, the first violation may now result in a warning along with an improvement notice instead of an immediate monetary penalty. However, this should not be interpreted as a relaxation of compliance obligations. The law has become significantly stricter for repeated violations. For example, in cases involving mandatory declarations on pre-packaged commodities, the second offence may attract penalties of up to 5 lakh rupees. For third and subsequent offences, penalties can range from 25 lakh rupees to 50 lakh rupees. Importantly, these liabilities also extend to digital modes of sale, including e-commerce platforms and online marketplaces. Similarly, violations relating to non-standard units and breaches of the packaged commodities rules have also witnessed substantial revisions. Another notable change is that the earlier provision allowing an offense to be treated as a first offense after 3 years has been removed. In addition, the Amendment Act provides for an automatic increase of the minimum fines and penalties by 10% every 3 years unless modified by law. These changes clearly indicate that while businesses are being given an opportunity to rectify genuine mistakes, repeated non-compliance will invite much stricter consequences. E-commerce compliance. The rapid growth of online commerce has also resulted in new compliance obligations. Beginning from the 1st of July 2027, e-commerce platforms dealing with imported products will be required to provide searchable and sortable country of origin information. Consumers should be able to easily identify where an imported product originates before making a purchase. This measure is intended to improve transparency and enable informed purchasing decisions. Businesses selling imported products online should begin preparing their product databases, catalogs, and digital listings well in advance to ensure compliance with these requirements. Customary Units Advisory. The government has also issued an important advisory regarding the use of customary units. Businesses may continue to display units such as inches, feet, or dozens. However, these can only be shown as supplementary information. The primary declaration must always remain in Standard International, or SI, units prescribed under Indian law. For example, a television may display its size as 55 inches, but the primary declaration should be in centimeters. Similarly, products sold by the dozen must continue to comply with the prescribed legal metrology declaration requirements. Businesses should review product artwork and packaging designs to ensure that SI units remain the principal declaration. LMPC Rules 2026. Several operational improvements have also been introduced under the LMPC rules. Importers are now permitted to undertake mandatory labeling activities at bonded warehouses operated by AEO Tier 2 and Tier 3 certified entities. This provides greater operational flexibility and reduces compliance bottlenecks. Companies are also required to disclose details of the director responsible for compliance during the registration process. Registration particulars must be updated annually through the online system, while registration certificates will continue to remain valid unless cancelled by the competent authority. These changes are expected to improve accountability, transparency, and ease of compliance for businesses engaged in import operations. Edible Oils and Fats Update. The Department of Consumer Affairs has revised the standard operating procedure for determining net quantity and standard pack sizes of edible oils and fats. The objective is to promote uniform packaging practices across the industry, improve price comparability, and enhance consumer transparency. The revised SOP recommends standard pack sizes for products such as palm oil, soybean oil, sunflower oil, mustard oil, groundnut oil, and rice bran oil. Businesses engaged in manufacturing, importing, packing, or marketing edible oils should carefully review their product portfolio and packaging configurations. Wherever required, they should update their packaging and labeling practices within the prescribed transition period to ensure compliance with the revised requirements. How mindsync can help. At mindsync, we understand that regulatory compliance can be complex and time-consuming. Our team works closely with manufacturers, importers, startups, MSMEs, and large organizations to simplify compliance and minimize regulatory risks. Our services include legal metrology advisory, LMPC registration, packaging and labeling reviews, import compliance, BIS certification support, quality control order compliance, regulatory audits, and ongoing compliance management. Whether you are introducing a new product into the market or reviewing your existing compliance framework, our experts are here to help. If you would like to discuss your compliance requirements or need professional guidance, feel free to get in touch with us. Thank you for watching this update. Stay informed, stay compliant, and stay ahead with mindsync.